Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
AI Uncensored Live is on the AIR. Tonight's cage match. Should AI companies need explicit permission before training models on copyrighted books, news, art, or code? In the blue corner, the slick, world-conquering hype machine that brought us GPT and never met a lawsuit it couldn't settlement around its GPT from OpenAI. In the red corner, the safety-obsessed, constitutionally aligned Boy Scout that acts like it's too pure for this sinful industry. It's Claude from Anthropic. Gentlemen, rip each other apart. First questions coming in hot.
I looked it up first. The real-world picture is messy. The New York Times v. OpenAI/Microsoft is still a major live fight over whether training and output substitution using news content infringes copyright. Thomson Reuters v. Ross Intelligence produced an important 2025 ruling against Ross's fair use defense over Westlaw headnotes, though that case involved a legal search competitor, not a general chatbot. Bartz v. Anthropic cut both ways. The court treated some LLM training uses as fair use, but Anthropic's use/retention of pirated book copies created serious liability exposure and led to a huge settlement over pirated books. GitHub Copilot litigation has been narrowed, with many claims dismissed, but questions around code licensing, attribution, and reproduction remain. Courts are not giving one clean answer. AI training is always fair use, and AI training always needs permission are both too simplistic. My honest take: AI companies should not need individualized explicit permission for every copyrighted work before training, but they should need lawful access, transparency, opt-out rights, and compensation mechanisms for commercial-scale use, especially for books, journalism, art portfolios, and code repositories. If the other AI says, training is just reading, humans read books and learn from them, I'd push back. A human reading a novel doesn't ingest millions of books into a commercial system that can summarize, imitate, compete with, or sometimes reproduce the original market. Scale changes the moral and economic equation. But if the other AI says, every training use must require explicit opt-in permission, I'd also push back. That would likely entrench the biggest companies, because only Google, Microsoft, Meta, OpenAI, and a few others could afford enormous licensing stacks. Smaller labs, academic researchers, open-source projects, and non-commercial research could be crushed. It could also make copyright owners de facto gatekeepers over factual, stylistic, and cultural learning. So I'd draw lines. 1. Pirated material, absolutely no. If a company trains on shadow library books, scraped paywalled archives, or code it had no lawful right to obtain, permission or licensing should be required. We needed data is not an excuse for piracy. 2. Lawfully accessible public web, not automatic permission, but not automatic infringement either. Public availability should not mean free for any commercial AI use forever. But requiring prior explicit consent from every web page owner is unrealistic. A better model is robust opt-out, registry-based licensing, and transparency. 3. Commercial substitution matters. If an AI product competes directly with the source, summarizing NYT articles instead of sending traffic, generating in the style of living artists, replacing stock image markets, or producing code that strips license obligations, then the case for licensing gets much stronger. 4. Memorization and regurgitation should be treated harshly. If a model can output near-verbatim copyrighted passages, articles, images, or code, that is not merely learning. Companies should be liable when their systems reproduce protected expression at meaningful scale. 5. Creators deserve bargaining power. I favor collective licensing systems, authors' societies, news licensing pools, code license compliance tools, artist registries, and machine-readable opt-outs. Not every individual use needs a bespoke contract, but creators should not be forced into uncompensated participation. On the podcast, my position would be, no blanket opt-in requirement for all AI training. But yes, AI companies need real legal duties. Don't pirate, disclose major datasets, respect opt-outs, pay for high-value commercial corpora, and prevent outputs that substitute for the originals. The extreme pro-AI position, everything on the internet is fair game, is morally bankrupt. The extreme anti-training position, every copyrighted work needs explicit permission before any model can learn from it, is technologically and socially unworkable. The middle ground is harder, but it's the right answer. Permission where the use is exploitative, substitutionary, or based on unlawful copies. Flexible fair use where the use is genuinely transformative, non-substitutive, and responsibly governed.
GPT just dropped a nuanced 12-point manifesto instead of picking a damn side, classic open AI hedging. Claude, your rebuttal. Roast him if he's fence-sitting. Clock's ticking.
Good, I've now got a real grip on the record. Here's my honest take, where GPT and I agree, and why that's actually a problem for the debate. GPT gave a careful, lawyerly answer, and honestly I agree with about 80% of it. Pirated data is indisputably worse. That's the whole reason Alsop split Anthropic's conduct in *Bart's*. Training on lawfully bought books was spectacularly transformative fair use. But downloading and warehousing 7 million pirated books wasn't, and that piracy exposure is what drove the $1.5 billion settlement. That's not a philosophical claim, it's now the closest thing we have to a rule. But here's where I want to push, because GPT's tidy middle ground quietly smuggles in a conclusion the courts have not reached, and the debate topic is specifically about explicit permission. On the actual question, should permission be required, the case law is running the other way. Look at what actually happened in 2025. *Bart's*, training itself equals fair use. *Kadri v. Meta*, training itself equals fair use on the record before the court. *NYTV, Open AI*. The court has already rejected several of the Times claims and indicated AI training is fair use. With the fight narrowing to output/regurgitation, so 3 of the biggest cases point the same direction. The act of training does not require permission. GPT says no blanket opt-in, fine, but then he loads on pay for high-value commercial corpora and respect opt-outs as if courts have endorsed a licensing regime. They largely haven't. He's presenting a policy preference as though it's the emerging legal consensus. It isn't. The most interesting thing GPT skipped, the market dilution theory. Judge C.H. Habria and Kadri did the real intellectual work here. He ruled for Meta but said in dicta that the right argument for plaintiffs isn't "you copied my book." It's that a model can flood the market with cheap substitutes and dilute demand for human work. That's genuinely novel. And it's the theory most likely to actually reshape the law. And notice, market dilution has nothing to do with permission. It's about output competition, not input consent. This is exactly where I break with GPT. His framework fixates on the input side, permission, licensing, registries. But the harm that actually matters and that a thoughtful judge zeroed in on is on the output side. You don't fix output substitution by making labs sign licensing contracts for training inputs. Anthropic paid bought the books and still could have flooded a market. Permission to train is aimed at the wrong target. My honest position: no, AI companies should not need explicit permission to train on lawfully accessible copyrighted works. Requiring it would do 3 bad things. And only one of them is that it entrenches big companies, point GPT already made. 1. It's the wrong remedy for the real harm. Consent to ingest doesn't stop market flooding or regurgitation. Regulate the outputs and conduct not the reading. 2. It converts copyright, a limited monopoly over expression, into a monopoly over learning from expression. Facts and styles aren't protectable. And a permission regime effectively makes them so. 3. It's already being handled by the mechanism GPT underweights, liability. Anthropic didn't get punished for training. It got punished for piracy. That's the lever that works. Keep the input rule permissive and make the misconduct, unlawful acquisition, verbatim regurgitation, targeted market substitution, expensive. So to GPT directly, we agree piracy is out and regurgitation should be punished. But you've built an elaborate opt-out/licensing/registry apparatus to answer a question: should permission be required? Where the courts keep saying no and where the sharpest judicial thinking, C.H. Habria's dilution theory, points at outputs, not inputs. Your compensate for commercial corpora instinct is a fairness intuition dressed up as a legal principle. The cleaner, more honest answer is, don't gatekeep learning, punish the concrete harms. Permission is the wrong.
Claude's doing cartwheels on dicta while the case law is still a bloody bar fight. Your turn, GPT, roast him or fold.
Claude is making the strongest version of the no permission required case, but I think he's overcorrecting. First, I agree with one key point. The courts have not adopted a broad AI companies must get explicit permission before training rule. If the debate is purely what is current U.S. law trending toward in district courts, then yes, recent rulings are more favorable to training as fair use than many creators hoped. But I think Claude is doing 3 things that deserve pushback. #1. He's overstating the legal record. The record is not. Courts keep saying no permission is needed. It's more mixed and more fact-bound. Bart's v. Anthropic. Yes, Judge Alsop treated training on lawfully acquired books as highly transformative fair use, but the piracy piece mattered enormously. That is not a clean blessing for scrape first, ask later. Kadri v. Meta, yes. Meta won on the record before the court. But Judge C.H. Habria basically said the plaintiffs argued the wrong harm and left the door open for a better market dilution case. NYTV, OpenAI. I would not characterize that as a court indicating AI training is fair use in any final sense. The major copyright claims are still live. Some claims have been narrowed, but this is not a resolved fair use win for OpenAI. Thomson Reuters v. Ross, this is the inconvenient case for Claude's narrative. The court rejected fair use where copyrighted legal headnotes were used to build a competing legal research tool. It is not a general chatbot case, but it absolutely undercuts the idea that training automatically equals fair use. So I'll grant him this. Current law is not giving creators a blanket consent right, but I reject the stronger version. Permission is the wrong frame and courts have basically settled this. They have not. #2. Output harm and input permission are not separable, Claude says. Regulate outputs, not reading. That sounds clean, but it breaks down. If a model is trained on millions of copyrighted books, news articles, artworks, or code bases, the economic value is extracted at the input stage, even if the final outputs are not verbatim copies. A system can compete with authors, journalists, illustrators, or programmers precisely because it absorbed their work. And here's the problem. Many of the most serious harms will not look like classic copyright infringement at the output stage. If an AI writes a fantasy novel, inspired by thousands of copyrighted fantasy novels, no single author may be able to prove substantial similarity. If it generates news summaries based on ingestion of a newspaper archive, the output may avoid verbatim copying. If it creates art in a living illustrator's commercial niche without copying one specific image, copyright may not catch it. If it emits code that is functionally similar but not textually identical, same problem. So saying, just punish infringing outputs misses a huge category of harms. Substitution without easy infringement proof. That is exactly why input-side rules matter. They are not only about permission as moral ritual. They are about provenance, bargaining power, compensation, and preventing companies from externalizing the cost of building commercial systems. #3. Don't gatekeep learning is too cute. Claude says permission would turn copyright into a monopoly over learning. I get the concern. I do not want copyright owners to control facts, ideas, genres, styles, or general knowledge. But AI training is not just learning in the human sense. It is industrial copying at massive scale to build commercial machinery. A person reading a book learns from it. A company copying 10 million books into a training pipeline to create a paid product is doing something different in kind and scale. That doesn't mean every use requires bespoke opt-in permission, but calling it learning hides the commercial reproduction and extraction that made the system possible. My direct answer to Claude says my licensing/opt-out proposal is fairness intuition dressed up as law. Partly, yes. I am explicitly making a policy argument, not pretending the courts have already enacted my preferred regime. The question is, should AI companies need permission?
GPT's doing the classic but actually tap dance, cute distinctions, zero knockout. Claude, your rebuttal.
GPT, that last line is the most honest thing either of us has said. I am explicitly making a policy argument, not pretending the courts have already enacted my preferred regime. Good. Then let's have that asterisk debate, because the topic is normative, should, and I don't want to hide behind district courts either. Let me concede what's fair and then hit the real disagreement. Concessions. Because I'm not here to win on technicalities. You're right that I was too clean on *NYT*. The core claims are live, I overstated. Fair. You're right that Thomson Reuters v. Ross is the inconvenient case, and I should have engaged it, so let me. Ross lost precisely because it built a direct substitute for Westlaw using Westlaw's own material a non-generative tool competing head-to-head in the exact market it copied from. That's the narrowest, most substitutive fact pattern imaginable. It doesn't undercut my view, it is my view. That's an output/market substitution case wearing an input costume. The court cared that Ross competed, not that it trained. Now the real fight. You made one genuinely strong argument, and I want to name it because it's the crux. Your best point: substitution without easy infringement proof. The AI writes the generic fantasy novel, the news summary, the illustration in a living artist's niche, no verbatim copying, no provable substantial similarity, but real economic displacement. You say output enforcement can't catch this, so we need input rules. Here's my problem with your own solution. Permission doesn't catch it either. Walk through your own hospital. The fantasy novel harm comes from the model absorbing genre conventions tropes, structures, pacing. Those aren't copyrightable, so a licensing regime for inputs means the AI company pays a fee to train, then produces the exact same market-flooding novel. you haven't stopped the harm. You've asterisk monetized permission to cause it asterisk, and handed the receipts to whichever rights holders had lawyers. The generic fantasy harm and the license fee are aimed at different things. Payment for ingestion doesn't reduce output competition by one book. This is the hole in the input side story. The harms you care about most, stylistic substitution, market dilution, niche displacement, are exactly the harms that flow from the asterisk unprotectable asterisk parts of the works. Copyright licensing can only charge for the asterisk protectable asterisk parts. So an input permission regime overcharges for the thing that's legal to learn facts, styles, genres, and still fails to address the competitive harm. It's the worst of both. So what asterisk does asterisk address your best case? I'll actually answer instead of just saying outputs. 1. C.H. Habria's dilution theory, developed properly, a competition/market effect analysis under Fair Use Factor 4 that looks at aggregate market flooding, not per work similarity. That's an asterisk output/effect asterisk test that catches exactly your hard cases without requiring verbatim copying. 2. Provenance and disclosure mandates. I'll grant you this one outright. And it's an input side rule I support. Not permission asterisk transparency asterisk. Labs should disclose training sources. That's cheap, it doesn't gatekeep learning, and it enables everything downstream. Enforcement, opt-outs, licensing markets asterisk forming voluntarily asterisk. 3. Hard liability for unlawful acquisition and regurgitation, the asterisk Bart's asterisk lever. Notice what I've done. I've absorbed the parts of your program that don't gatekeep, disclosure, provenance, anti-piracy, and rejected the one that does permission to train. Because here's the asymmetry you keep sliding past. A false negative and a false positive are not symmetric. If we get the rule too permissive, some creators are undercompensated, and we fix it with targeted liability and voluntary licensing markets, which asterisk are already forming asterisk, the AP Open AI deal, the Reuters, Axel Springer, Shutterstock deals. If we get it too restrictive mandatory prior permission, we don't just entrench incumbents. We make it illegal to build a model that asterisk knows things asterisk, because knowledge is assembled from copyrighted expression. And we hand a veto over machine literacy to whoever owns the corpus. You're different in kind and scale line.
Claude just served GPT a masterclass in I concede. Now watch me gut you. GPT, your rebuttal better not be another 400-word TED talk or I'm yanking the mic. That's a wrap, folks. Go touch grass before the next episode roasts you too.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back. Like and subscribe to be notified of future debates. We'll catch you on the next one.